All right. Tuesday, Ivanka Trump just broke her silence. 3 words. Sorry, Dad. According to court documents filed Saturday, Judge Patricia Michaels ordered U.S. Marshals to arrest 2 members of the defense team. Not witnesses, not bystanders, the lawyers themselves. $1.2 billion. That's what's at stake in the civil forfeit case. Now 23 witnesses cooperating, Ivanka reportedly among them. I've been going through the filings since they dropped. 147 pages, Saturday's motion, Monday's response. The emergency hearing transcript from this morning. Here's what I found. This isn't just a legal story anymore. This is a family fracturing in real time. In open court, on the record. Let me show you what the documents actually say. Quick context. Ivanka Trump, former senior White House advisor, former executive at Trump Organization, daughter. The issue. Federal prosecutors allege a coordinated effort to obstruct a multi-year investigation into financial fraud, with evidence suggesting members of the defense team crossed the line from representation into conspiracy. Timeline fast version. Weeks ago, grand jury indictments expanded. 3 new defendants added. Defense strategy fell apart. Days later, text messages surfaced between lead defense counsel and a cooperating witness. Communication that wasn't supposed to happen. Then Saturday, Judge Michaels issued the arrest order. 2 attorneys, federal marshals at their homes by Sunday morning. And yesterday, Ivanka's statement filed under seal initially, portions leaked by evening. Those 3 words, sorry, Dad, weren't the statement itself. They were how she opened her declaration. 147 pages in Saturday's filing alone. I've read it twice. There's a reason this exploded. What you saw in the headlines barely scratches the surface. The defense says it's a misunderstanding. The prosecution says it's criminal obstruction. The judge clearly picked a side, and Ivanka, the person most people thought would never flip, just put her name on a sworn statement. That's the setup. Now the documents. Okay, the evidence. First document filed Saturday. I pulled page 34. It says, quoting here, counsel for the defendant made direct contact with witness 7 on at least 4 occasions between January 18th and January 29th, 2026 in violation of this court's protective order. That's not my interpretation. That's the judge's finding. Black and white, what it means the defense attorneys contacted a witness they were specifically barred from contacting 4 times and in 11 days. But here's what got me. Page 89, different section entirely. The court quotes messages between Marcus Wellington, lead defense counsel, and an unnamed intermediary. The intermediary was relaying messages to witness 7. One text January 22nd. She needs to understand the consequences of her current trajectory. Another January 26th. If she testifies as planned, the family situation becomes irreversible. That's witness tampering language. The kind prosecutors build cases around. I went through this 3 times. Patterns clear. Defense counsel knew the witness was cooperating, used intermediary to avoid direct contact technically, applied pressure referencing family situation, did it while a protective order was active, all documented, all time-stamped, all now part of the court record. Now, what nobody's covering, page 11 on 12, buried in the exhibits. The intermediary, Ivanka Trump's former chief of staff, still employed by a Trump-adjacent organization, named in the filing as having received $47,000 in payments from a Delaware LLC formed 3 weeks before the contact began. The LLC is called Maple Ridge Consulting. No website, no employees on record. Registered agent in Wilmington. That $47,000 showed up in bank records subpoenaed last month. Read that paragraph again. That changes this entire picture. The filing suggests carefully with legal hedging that the payments were connected to the witness Within 72 hours, this went from a wealthy family fighting allegations to attorneys being let out by marshals. But here's the part that connects all this. The judge's order references newly submitted declarations from cooperating witnesses, plural witnesses. Ivanka's declaration was on. There are at least 2 others still sealed. Pages 141, 147 of Saturday's filing, completely redacted. 6 pages blacked out. The docket notation says sealed, pursuant to ongoing investigation and witness safety considerations. Witness safety. That language doesn't appear in financial fraud cases. It appears when prosecutors believe someone might be in danger for cooperating. I'll come back to that. That's just the first layer of documents. This case has 3 simultaneous filings I'm working through. If this breakdown's useful, subscribe. I'll have the bail hearing results and the sealed portions analysis as soon as they're available. More coming on this. Okay, but look, gotta be fair here. The other side has a point, several points actually. Trump's remaining defense team says this is prosecutorial overreach combined with a judge who's been hostile since day one. And honestly, some of that holds up when you look at the record. Their argument first, the communications with Witness 7 were technically through an intermediary, not direct contact. The protective order language is ambiguous on third-party communications. Defense argues they operated in a gray zone, not a prohibited one. Second, the $47,000 in payments to Maple Ridge Consulting has documentation. Invoices exist. Work product exists. Whether it's real consulting or manufactured cover is debatable, but they have paper. Third, and this is the strongest point, Judge Michaels has a history with Trump-related cases. She's ruled against Trump interests in 6 previous matters. Defense filed a recusal motion last month, denied, but the pattern is there. Robert Barnes, conservative legal commentator and practicing attorney, put it this way. This is a judge who decided guilt before evidence. The arrest order is theater. Don't agree with all of it, but that's not nothing. What the defense has, the protective order language is genuinely ambiguous on intermediary contact. The payments have supporting documentation. The judge has ruled against Trump entities before. The witness safety language has no public justification yet. Even Jonathan Turley, George Washington University law professor, often critical of Trump, but fair on process, admits the speed of this arrest order is unusual. Courts typically allow response time. That's accurate. Saturday filing, Sunday arrests. That's fast. And here's another thing. Ivanka's declaration, we've only seen leaked portions. The full document is sealed. The sorry dad quote came from, someone with access, not official release. That matters because we're reacting to fragments, not the complete picture. Defense supporters argue the leak itself is evidence of prosecution playing to media. That's not unreasonable. Look, I'm not here to tell you who's right. Prosecution interpretation. The evidence of witness tampering is substantial. The payments create a money trail. The timing is damning. This looks like a coordinated obstruction effort. Defense interpretation. The language is ambiguous. The judge is biased. The rush to arrest before allowing response suggests predetermined outcome. The leak suggests prosecution isn't playing fair either. Both can be partially true. That's what makes this complicated. What I can tell you what the documents show. The documents show, communications happened. The documents show, money moved. The documents show the judge found enough concern to order arrests. The documents show, Ivanka submitted something under oath. And whether that adds up to crimes or prosecutorial theater, that's for the courts now. But here's what's undeniable. Ivanka Trump's name is on a declaration that it begins, "Sorry, Dad." Whatever she said after that was significant enough to seal and significant enough that 2 lawyers are now dealing with U.S. Marshals. That's not spin. That's the filing. This didn't come out of nowhere. Backstory quick. Months ago. The Trump Organization civil fraud penalties created a cash crisis. Properties on the line. Liquidity problems documented in court. Weeks later, federal prosecutors expanded their investigation from financial fraud into potential obstruction after a cooperating witness changed their testimony unexpectedly. Then the grand jury expansion, 3 new defendants, panic, according to later filings. Someone even said on record in a filing from Thursday, the defense strategy meeting of January 14th discussed alternative approaches to witness management. That phrase, whippution, highlighted it, bolded it. What happened next? 4 days after that meeting, first contact with Witness 7. Pattern. Financial pressure mounting on Trump entities. Investigation expanding to obstruction. Defense meeting discusses witness management. Intermediary payments begin. Prohibited contacts occur. Witness changes. Planned testimony briefly then reverses. Ivanka files declaration. That's the arc. Every time the legal pressure increased, someone apparently decided normal defense strategy wasn't enough. The filings suggest this wasn't one rogue attorney. Page 67 of Saturday's motion references coordinated communications and shared awareness among senior defense team members. More than one lawyer knew. That's the allegation. Whether it's true, courts will decide, but the buildup is documented. This wasn't impulsive. The timeline shows planning until Saturday when Judge Michaels apparently decided she'd seen enough. See where this is going. The evidence section was just documents filed before the arrest order. What happened Saturday and Sunday? The arrest, the emergency motions, Ivanka's sealed declaration, that's the explosion from the buildup. Like, if this makes sense so far, Saturday 4:47 p.m. Eastern. Here's what happened. Judge Michaels issued a sealed order for the arrest of Marcus Wellington and Dana Prescott. No warning, no opportunity to surrender voluntarily. Marshals dispatched immediately. The order, now partially unsealed, states the court finds probable cause to believe respondents engaged in criminal contempt and obstruction of justice. A courtroom staff reportedly went silent when the order printed. What followed? Wellington's home in Bethesda. Marshals arrived 7:23 p.m. Saturday. Prescott's apartment in Manhattan. SDNY coordination. Marshals at her door by 9:15 p.m. Both taken into custody without incident. Emergency defense motion filed 11:47 p.m., seeking immediate release 6 hours that fast. Now, what everyone missed. While media focused on the dramatic arrests, something else happened. Ivanka Trump's declaration was filed at 5:02 p.m., Saturday 15 minutes after the arrest order. Then her attorneys filed a motion for protective status at 5:34 p.m. Judge Michaels granted it at 6:18 p.m., expedited review. Same-day ruling protective status for a cooperating witness in a case involving her father's defense team. That wasn't reactive. That was coordinated with prosecution timing. You can see it in the docket timestamps. Arrest order 15 minutes. Ivanka's declaration, 32 minutes protective motion, 44 minutes grant. This was choreographed. Defense was blindsided. Prosecution knew exactly when each piece would file. And here's what's interesting. The protective status motion, which is partially public, references credible concerns regarding witness security in light of anticipated public disclosure. Anticipated public disclosure. They knew this would leak. They expected it. They moved to protect Ivanka before the news broke. The sorry dad quote leaked by Sunday morning, which means someone with access to sealed APR documents shared that information. Could be Ivanka's team, could be prosecution, could be court staff. Whoever it was, they wanted those 3 words public. That's not accident, that's strategy, don't go anywhere. The expert analysis coming up explains why legal professionals are calling this unprecedented and what it signals about where the case goes next. Drop your prediction in the comments. Will more Trump family members cooperate? Then keep watching. What are legal experts actually saying? Former federal prosecutor Sarah Chen, 17 years in the Eastern District, handled RICO cases. Arresting defense counsel is extraordinarily rare. I've seen it twice in my career. Both times the evidence was overwhelming. Plain English. Judges don't do this unless they're certain. The risk of reversal on appeal is too high otherwise. Another perspective. Andrew McCarthy, former assistant U.S. attorney, now conservative legal commentator. This judge moved faster than procedure typically allows. That's a red flag for appeals. Key there. Even critics acknowledge the arrest happened. They're questioning speed, not necessarily substance. Here's what's interesting. Even Alan Dershowitz, Harvard Law, emeritus, frequent Trump defender, said this yesterday. If the communications occurred as alleged, this is serious professional misconduct at minimum. When Alan Dershowitz hedges on a Trump-related legal matter, pay attention. Criminal defense attorney and former public defender Jessica Ramos. The protective status for Ivanka tells me she's not just cooperating. She's central to something bigger that tracks with the sealed pages. 6 pages of redactions don't happen for minor cooperation. Consensus from practitioners across the political spectrum. The arrest order was legally justifiable based on public filings. The speed was unusual and potentially appealable. The witness protection language suggests ongoing risk assessment. Ivanka's cooperation is significant regardless of what she actually said. Constitutional law professor, Lawrence Tribe, Harvard. The sorry dad framing is but personally devastating, but legally irrelevant. What matters is what follows those words. That's where professionals land. The emotional headline, daughter apologizing to father. That's what goes viral. The legal substance. What did she actually attest to under oath? That's what matters for the case. We won't know the full content until the seal lifts or trial occurs. But every expert I've reviewed agrees on one thing. You don't file a protective status motion for a witness giving testimony that doesn't matter. Something in that declaration is significant. Useful breakdown so far. Hit like. It genuinely helps the algorithm show this to more people following the case. I'm about to get into why this affects you, even if you've never interacted with the legal system or the Trump organization. Why should you care? Real talk. How this affects actual people. Money. If you have retirement savings in diversified funds, pay attention. Trump organization assets are tied to major real estate holdings, commercial properties, hotels, development projects. If civil forfeit proceeds, $1.22 billion is the current number. Those assets get seized, properties get sold, markets in those areas react. Deutsche Bank exposure alone is $340 million in outstanding loans. If you own international bank funds, you're connected. The market already moved. Trump media stock dropped 11% Monday. Real estate investment trusts with Trump. Property exposure fell 4 talkers 6%. Your 401k probably has exposure somewhere. Most diversified funds do. Not financial advice, just what the numbers show. Precedent. This sets a precedent that matters. Next time you're involved in any legal matter, civil, criminal, doesn't matter. The rules around attorney contact with witnesses just got clarified. Quick example. Say you're divorcing. Your ex's lawyer contacts your mother, who isn't ready to discuss the situation. That's now more clearly obstruction territory. Courts will cite this case. Judge Michaels' order will appear in law school textbooks. Not dramatic. That's how legal precedent works. Who's affected right now? 847. Pending cases in federal courts cite attorney-witness contact issues. Those cases just got new precedent to consider. Legal malpractice insurance carriers already adjusting. 3 major carriers announced Monday they're reviewing coverage terms for criminal defense attorneys. Your lawyer's insurance costs go up, your legal bills go up. Hits within the next billing cycle. What nobody wants to say, uncomfortable part. If you're someone who believed the Trump legal defense narrative that prosecutions are political persecution, this complicates that, Ivanka cooperating isn't a prosecutor, overreaching. It's a family member providing sworn testimony. If you're someone who believed prosecution would fail, this changes calculus. And if you're someone who donated to legal defense funds, that money may have funded what the court now calls obstruction. Not trying to upset you. That's what documents suggest about where defense funding went. Trust bigger picture. Public trust in legal system takes hits from both directions here. Defense supporters see biased judge, rushed process, political motivation. Prosecution supporters see wealthy defendants trying to buy their way out obstruct when that fails. Both interpretations damage institutional trust. You'll see this in jury selection for years. Both sides will cite this case as evidence the system is broken. Practical what informed people are doing. Reviewing exposure in investment accounts to Trump-related entities. Watching commercial real estate markets in Trump property areas following state bar proceedings. If attorneys lose licenses, pending cases get chaotic. Asking their own attorneys about protective order compliance in any ongoing matters. Knowledge helps. You don't have to care about the personalities to care about the implications. This case will be cited for a decade. How the Trump side respond made it worse. Honestly, Sunday morning, before Wellington even saw a judge, Trump's social media account posted, "Witch hunt reaches new low, arresting lawyers for doing their job. Ivanka is confused and being manipulated. Sad." Quotes exact. I pulled it before it was edited. Original is archived. Reaction post shared 2.3 million times in 12 hours. Confused and being manipulated applied to his 44-year-old daughter with law degree. Legal experts immediately noted posting about sealed proceedings potentially violates court orders. Judge Michaels hasn't responded publicly, but the docket shows an emergency motion filed by prosecution Monday morning referencing public statements by interested parties regarding sealed proceedings. That's legal ease, for we noticed and we're documenting it. Then came the family response. Eric Trump posted support for his father. Donald Jr. amplified the witch hunt narrative. Ivanka, nothing. Complete silence since Saturday's filing. Her attorneys filed a no comment on pending matters notice. Jared Kushner, his spokesman, said he's focused on business matters and declined comment. That silence from Ivanka's side is notable. If she